Hi everyone. I hope everybody is doing well. Today I will be discussing competence to refuse an insanity defense, which is just the overall understanding of when someone can say no to a mental health defense. Um, that is the section that I was assigned, so I'm just gonna try to give you all a little bit of insight. I also feel like this is just an overall important issue because it sits at the intersection of mental health and legal rights. Hopefully, by the end of this presentation, you all will understand why this topic matters, the legal standards involved, and how courts make these tough decisions. Um, Overall, let's just start with, an introduction. What is competence? Competence in the legal system means that a person has the mental ability to participate in their defense. This includes understanding charges, especially in forensics matter, working with their lawyer and making informed legal decisions. Um, the idea of competence has been around for centuries, dating back to the 17th century. In English law, courts recognize that it is unfair to try someone who didn't understand what was happening to them. Especially in the US, competence is protected under the Sixth Amendment, which guarantees the right to fair trial, legal representation, and just the ability to confront witnesses. If a defendant isn't competent, these rights become meaningless. Think of it as if you were to say, or if you were sick and you were to say, I don't want any medicine, um, should the doctor force them to take it? Um, Getting into the history of competence of, like I said, courts have long believed before that a person must be mentally present to have a fair trial. This has been established since the 1700s. Judges have delayed trials for defendants who weren't mentally fit, and around the 1800s, courts made it a rule if someone is too sick to understand, they shouldn't be punished unfairly. Um, I want to get a little bit into Dusky versus the United States. Um, to determine if someone is competent, courts have used the Dusky standard from 1960 Supreme Court case study, um, where this test asks two main questions. Um, can the person understand their trial? So basically, does the defendant understand the legal process? And the second question being, um, can they help their lawyer with their defense? So basically, can they assist in their own defense? This means that they don't need to be a legal expert, but they must have enough mental awareness to participate in their trial fairly. And then when it comes to competence versus insanity, um, competence is where, can the person stand trial to make these decisions? And then when it comes to insanity defense, again, saying, was I too mentally ill when I committed the crime? But a big question that often comes across is, what if someone refuses insanity defense, even if it could help them, which happens a lot in a lot of cases. Um, the key questions here when it comes to can you refuse an insanity defense? Uh, the court would ask, does this person truly understand what they are rejecting? A lot of times, insanity defense is used when a defendant claims they were not mentally capable of understanding their actions at the time of the crime. Other mental state defenses, like diminished capacity, can sometimes argue that a person's mental illness affected their ability to form intent. Um, but some people with severe mental illnesses refuse insanity defense even when it could prevent them, just because, which is often can be deemed as controversial because people can refuse for irrational reasons, like tarnishing their um, their name. They may not want their business to be out there locally, things of that nature.
In Ferretta versus California, the United States Supreme Court held that a criminal defendant has a right to waive his Sixth Amendment right to counsel and defend himself at trial. But what if the defendant is so mentally ill that despite being mentally competent to stand trial, he lacks the capacity to represent himself at trial? Does Ferretta still require a trial court to allow such a defendant to represent himself? The court addressed this issue in Indiana versus Edwards. Ahmaud Edwards attempted to shoplift shoes. After the store's security officer confronted him, Edwards fired a pistol, wounding a bystander. Edwards was charged with theft, attempted murder, recklessness, and battery. Because he was indigent, the trial court appointed Edwards an attorney. After a psychiatric evaluation concluded that Edwards was schizophrenic and delusional, the court found that Edwards was incompetent to stand trial under the standards set forth in Dusky versus United States. The court then committed Edwards to a state psychiatric hospital for treatment. After a lengthy period of treatment, the court found that Edwards had regained his competency. At his jury trial, Edwards asked to represent himself, but the court denied the request. Edwards' court-appointed counsel represented him at the trial. The jury convicted Edwards of criminal recklessness and theft, but couldn't reach a verdict on the attempted murder and battery charges. At his retrial on the latter two charges, Edwards again asked to represent himself. Citing the psychiatric reports, the court found that Edwards suffered from severe schizophrenia and concluded that, although Edwards was competent to stand trial under Dusky, he wasn't competent to defend himself at trial pursuant to Ferretta. The court thus denied Edwards' request. Edwards was represented by appointed counsel at his retrial. The second jury convicted Edwards of attempted murder and battery. On appeal, the Indiana Court of Appeals reversed Edwards' convictions, concluding that the trial court had violated Ferretta by not allowing Edwards.
So overall, the whole entire purpose of me pulling this information was to basically show a clear example of what that looks like. In this case, Ahmaud Edwards was charged with attempted murder, but was found incompetent to stand trial. After being treated, he was later deemed competent. However, he wanted to represent himself at trial, even though his mental health was still very questionable. The overall Supreme Court ruled that while Edwards was competent to stand trial, he was not competent to represent himself. So the court decided that states can require higher competence for self-representation for standing trial. I know a big question is, why does this matter? This case shows that competence is not a simple yes or no decision. Courts must consider different levels of competence depending on the legal choice of a defendant wants to make. This basically just means the judge can decide if a person truly understands what they are rejecting when it comes to that. Again, why does this matter? Some people believe everyone should have the right to decide their own offense. Others think that courts should step in if someone is too sick to make a smart choice. Again, the big question is always, where should this line be drawn? I also want to include just overall what balancing rights versus protections are before we get into the big picture. So why does this issue matter? Why does courts have to balance two key ideas? A defendant's right to control their own case. In the US, personal freedom is highly valued. If someone is competent, they should have the right to make their own legal decisions, even bad ones. Protecting individuals who may not understand their choices. If a person has severe mental illnesses, should we let them make choices that could hurt them? Courts must decide if allowing a defendant to refuse insanity defense is their decision or a symptom of their illness. Overall, though, again, like the big picture is